Attorney Kevin Reddington said DNA gobbledygook in court today, and I got a chuckle, because the last time I heard that term used was back when Obama said it on Late Night with Stephen Colbert, and I'm realizing a lot of people on the internet don't know that it's a real term. It was coined in 1944 by Texas Congressman Maury Maverick, who said that confused government writing sounds like turkey gobbles. Gobbledygook. Anyway, that's not the point of this video. I wanted to take a break from the heartbreaking testimony and just the heaviness of everything we've learned in the last 7 days of the Lindsay Clancy trial to really give Attorney Reddington his flowers. Now, I'm going to be the first to admit I was a little skeptical because of his advanced life experience. I was wondering how he would fare up against all of the digital and forensic evidence, but these last 7 days have proven me completely wrong. I have been given a masterclass in trial advocacy. Now, say what you want about his defense strategy. I think the mark of great trial attorneys is not just how well they can ask questions, but how they can expose weakness or challenge certainty, or just take a piece of evidence and completely change the way you look at it without ever having to introduce a single new fact. I'll show you what I mean. I'll start with Patrick Clancy. Reddington began his cross-examination gently. Using a soft-spoken, sympathetic tone, he asked Patrick what kind of mother Lindsay had been. Patrick described her as devoted. He said she read to the children from infancy, made up songs for them, and, quote, did everything. He also testified that he began noticing a deterioration in her mental health around September of 2022, and this is where Reddington's strategy began to form. Rather than challenging Patrick personally, he focused on the parts of Patrick's testimony that supported two important pieces of the defense theory. Lindsay had been a loving and involved mother, and the change in her mental health was noticeable to the person living beside her. He then slowed down the prosecution's evidence surrounding an apparent suicide-related Google search. Reddington had Patrick explain that the search may have resulted from him looking up a country musician who died by suicide and clicking through the related content. Here, Reddington did not have to prove that the prosecution's interpretation was impossible. He simply showed the jury that the digital evidence may have had another reasonable explanation, aka he challenged certainty. Dr. McDonough's testimony produced what I consider to be one of the strongest cross-examinations of the trial so far. McDonough was one of the emergency physicians who treated Lindsay at South Shore Hospital. On direct examination, the prosecution emphasized that Lindsay's wrist and neck wounds were relatively superficial. But on cross, Reddington didn't stay focused on the cuts. He shifted the jury's attention to Lindsay's overall condition when she arrived at the hospital. He established that Lindsay was nonverbal, responsive only to pain, and had to be intubated. Then he began testing how much Dr. McDonough actually remembered from that day. He asked whether Lindsay's pupils had been equal and reactive to light. I don't recall. He asked whether she remembered Lindsay's core body temperature. If that's what the record says, then yes. But you sit here today, you don't know what her core body temperature was? I saw her 3 years ago. I see about 200 patients. Then came the moment that immediately caught my attention. Reddington interrupted and said, "I'm sure you're very busy, but this is a murder trial, doctor. Did you review your records and your notes before you came in here today to testify on this case?" She responded, "Sir, I did, but I don't have a photographic memory." He didn't argue with her, and he didn't accuse her of anything. He simply shifted the jury's attention from the medical opinions themselves to the foundation those opinions were based on, and this is something I was fascinated by. When a witness answers confidently on direct examination but repeatedly says, "I don't recall," during cross, an experienced trial attorney may begin testing the witness's preparation instead of continuing to debate the medicine. And one thing I noticed, and maybe you noticed it too, is that after this exchange, those repeated "I don't recall" responses became much less frequent. So, whether it's coincidence or not, I'll let you all decide. Then, with Dr. Gilan Biswas, Reddington used a completely different technique. Instead of confronting her, he narrowed her opinion. He established that Biswas had evaluated Lindsay only once for approximately 20 to 30 minutes. He then asked whether psychosis can fluctuate. Answer was yes. Whether someone experiencing psychosis can also have periods of clarity. Again, yes. He did not argue with her conclusion or attempt to force her to diagnose Lindsay with psychosis. He simply placed boundaries around what her testimony could establish. A brief evaluation during which a clinician could not personally observe psychosis does not necessarily establish that psychosis was never present. And in a trial centered on Lindsay's mental state at the time of the killings, that distinction is crucial. And then DNA gobbledygook. Before Day 7's testimony continued, the defense agreed to several facts surrounding the collection, handling, and testing of physical evidence. That is called a stipulation. It means the defense is agreeing that certain facts are not disputed. That can eliminate the need for prosecutors to call multiple witnesses simply to establish chain of custody, laboratory procedures, or the authenticity of evidence. The defense was not disputing that Lindsay killed the children. The dispute is whether she was criminally responsible because of her mental condition. Both sides had also agreed that Lindsay's DNA and the children's DNA were found on the exercise bands. So when the testimony continued, moving deeper into technical DNA analysis, Reddington objected and called it DNA gobbledygook. His point was simple. The identity of the DNA was no longer disputed. The defense had already conceded it. From Reddington's perspective, continuing to immerse the jury in technical forensic testimony risked placing unnecessary emphasis on a fact that did not answer the central question in the case. The issue for this jury is Lindsay's mental state, not whose DNA was found on the bands. At this point, I chuckled, not because this case is funny, it absolutely isn't, but because gobbledygook gives such strong old-school lawyer talk, and it was slightly cantankerous, but still legally on point. He rarely argues with the evidence in this trial. Instead, he challenges the certainty and introduces other possibilities. And as someone who has always been fascinated with the legal system, I've been watching court trials from a very young age. I was glued to court TV. This is exactly the kind of lawyering that piques my interest and keeps me glued to the TV set. Now, I want to know your thoughts. What was your standout moment, whether in cross-examination, an objection, or a court moment where you were like, I didn't see it that way until he presented that alternative theory? Let me know in the comments. I'll be reading. It could be gobbledygook.